Good evening and welcome to Courts Today by Live Law. This is your host Urvashi Chauhan bringing you the latest updates on the legal front. This is your go-to source for all things legal. Let us start. I start with the much anticipated judgment of the Supreme Court delivered today, that is on the batch of pleas challenging Gujarat government's decision to grant remission to 11 convicts sentenced to life imprisonment for multiple murders and gang rapes, including that of Bilkis Bano during the 2002 communal riots in Gujarat. You must have seen the visuals from 2022 Independence Day when the live convicts were allowed to walk free, welcomed with garlands, thus sparkling widespread controversy. Before Bilkis Bano herself approached the top court, a number of petitions had been filed in public interest challenging the remission. The petitioners and advocate Shobha Gupta, who appeared for Bilkis, argued that the punishment imposed on her rapists ought to be proportional to the nature and seriousness of the crime they had committed, which included 14 murders and 3 gang rapes. The government, as well as the convicts, challenged the maintainability of these writ petitions, saying that they did not have any locus standi. Not only did they argue that the remission was legal, but the reformative theory of punishment was also cited, saying that even those convicted of heinous crimes deserve an opportunity to reform themselves. While delivering the judgment today, the bench comprising Justices B.V. Nagaratna and Ujjal Bhuyan has set aside the remission. The court significantly held that the state of Gujarat was not the appropriate government to decide the issue of remission, as the trial was held in the state of Maharashtra. So, as the Gujarat government was incompetent, the remission orders were held to be invalid. Accordingly, the court has directed the convicts who were given premature release to surrender in prison within 2 weeks. Also, I would like to tell you, back in May 2022, the Supreme Court had instructed the state of Gujarat to review remission application for another convict named Radheshyam Shah under its 1992 policy. In that case, the court had said that after the crime occurred in the state of Gujarat and the trial concluded with a conviction, all subsequent proceedings, including remission or premature release, must adhere to the policies applicable in the state where the crime took place. The bench today said that although the top court had instructed state of Gujarat to review the remission application for Radheshyam Shah, the bench now found that Shah had obtained the order by deceiving the court, involving fraud and withholding important information. The court has thus slammed the Gujarat government for acting in tandem with Shah and not seeking review of this May 2022 judgment. The Supreme Court today stayed the direction issued by the Bombay High Court to the Election Commission of India to hold by-election for the Pune Lok Sabha seat. The seat has been vacant since the death of MP Girish Bapat in March 2023. The bench comprising CJI Chandrachud, Justices J.B. Pardewala and Manoj Mishra passed the interim order today while issuing notice on the SLP filed by the Election Commission assailing the High Court's order. The High Court had rejected the Election Commission's contention that it was difficult to hold a by-election. It emphasized that constituencies cannot remain unrepresented beyond a defined period, stating that in a parliamentary democracy, governance relies on elected representatives who are the voice of the people. The Supreme Court observed that Section 151A of the Representation of Peoples Act would come into play in this case. According to this provision, the ECI need not hold by-election to fill up a vacant seat if the remainder of the term in relation to the vacancy is less than 1 year. The matter will now be posted in March or April. Stay tuned with us. The Supreme Court has agreed to form a bench to hear a plea expressing concerns about Collegium system used for appointing judges in both the Supreme Court and the higher judiciary. An advocate today mentioned the petition before the CJI for urgent listing. He referred to an interview by the recently retired Supreme Court Judge Justice Sanjay Kishan Kaul, who had highlighted faults in the present Collegium system. Recently, Justice S.K. Kaul, in an interview with the PTI, emphasized the internal frictions within the present Collegium system. As a former member of the Collegium, he noted that the Supreme Court's striking down of National Judicial Appointments Commission Act in 2015 caused dissatisfaction among political circles. The NJAC Act had been unanimously passed by these circles, and its nullification affected the smooth functioning of the Collegium. According to Justice Kaul, the delays in the government's approval of appointments recommended by the Collegium reflect the ongoing tensions within the system. The Supreme Court has dismissed a plea challenging discontinuation of the court-monitored probe into the 2013 murder of anti-superstition crusader Narendra Dabholkar, who was shot dead by extremist elements on his morning walk in 2013. It was observed that the Bombay High Court order declining to continue monitoring of the probe was reasonable, and monitoring could not be at the pleasure of a party. The division bench of Justices Vikram Nath and Satish Chandra Sharma, however, left it open for the petitioner, that is Mukta Dabholkar, who is daughter of Narendra Dabholkar, to provide any material related to the criminal cases in question to the CBI. The murder investigation was transferred by the Bombay High Court in 2014 from Pune Police to CBI, and since then the progress of the case was being monitored by the High Court. In April last year, the High Court refused to continue with the same, observing that monitoring could not be perpetual. In another update, the Supreme Court today refused to interfere with the Allahabad High Court's order upholding acquittal of Union Minister of State for Home Ajay Mishra Teni in the murder case of Prabhat Gupta. Prabhat was a rising student leader and was killed in broad daylight in Lakhimpur Kheri district in the year 2000. 4 people, including Union Minister Teni, were named as accused. In 2004, Teni was acquitted by the lower court. The High Court dismissed the revision plea and the state's appeal against the order of the lower court. And so, the present appeal was filed before the apex court. The matter was placed before the bench of Justices Bela M. Trivedi and Pankaj Mithal, which said that it is not inclined to interfere with the concurrent findings of the High Court and of the trial court. The Kerala High Court today allowed the anticipatory bail application moved by actor and politician Suresh Gopi in connection with the case for alleged misbehavior with a female reporter in front of the public and media. A complaint against him was initially filed alleging sexual harassment, which was later altered to criminal force to outrage the modesty of a woman. In his plea, Gopi argued that he was proceeding to his hotel room when media persons surrounded and restrained his movement in the hotel lobby. He was only trying to remove the obstruction caused by the media persons, which included the female reporter also. He has also submitted that he was innocent and had not touched the female reporter with any sexual intent or motive. Justice Sophie Thomas today said that custodial interrogation of Gopi was not needed for the purpose of investigation on the assurance that he was ready to cooperate with the investigation process. It further noted that the de facto complainant or the victim also had no objection to the bail application. And lastly, the Allahabad High Court has observed that firing a pistol in self-defense does not violate license conditions. Justice Subhash Vidyarthi passed this order on an application challenging an order of the Special Chief Judicial Magistrate, wherein the applicant's application for release of pistol, 4 live cartridges and pistol license had been rejected. To tell you a little bit more about the facts, the applicant in this case was charged under various sections of IPC and Arms Act for allegedly firing a gun with the intention to harm others. Despite no reported injuries, he was charged. He sought the release of his licensed pistol and cartridges, but the request was denied by the Chief Judicial Magistrate. He appealed to the High Court, arguing that the prosecution failed to prove injuries and that the firing was in self-defense. The court considered a statement from the sister of the co-accused who said that the applicant tried to help someone being beaten by a crowd. When the crowd turned violent, the applicant fired his gun into the sky and both individuals escaped to save themselves. The court said that Section 30 of the Arms Act, which declares violation of conditions of arms license to be an offence, does not include the act of firing in self-defense. So the court set aside the order passed by the Special Chief Judicial Magistrate and ordered the release of the pistol. Thank you for watching. If you wish to know more details about the cases I mentioned here, you can visit our website at www.livelaw.in. Stay ahead with quick legal updates only on Live Law. Do not forget to like, share and subscribe and support us. You can also support us by donating through the thanks button at the bottom of our videos or consider becoming a member at just 89 rupees per month.